Hello everyone. Welcome to our first meeting. Uh, Here we will be discussing the first three chapters from Anarchy and the Law. It's a compilation that is done by Professor Stringham. So the first chapter is simply an introduction by him, and second chapter is an extract from Murray Rothbard's book For a New Liberty. And third chapter is an extract from David Friedman's book, Machinery of Freedom. So, so let us begin. Is government necessary? Usually here people say that government is a necessary evil. The evil part is hardly refuted except by the most staunch statists. In this series, we would, however, concentrate on the necessary part. For the most part of this course, we will not be going into the economics of status violence, except when we are discussing police and courts. There are a lot of liberal thinkers who believe that there should not be a government monopoly over food. That food is too vital for survival to be left in the hands of the government. Like Milton Friedman said, that if you put government in charge of Sahara Desert, in 5 years there'd be a shortage of sand. But then the same liberal asks, why should this? But then, when the same liberal asks, why should the same logic not apply to the field of security? Security is, in my opinion, is far more valuable, if not equally valuable, than food. Why should we therefore leave the aspects of our life, like law and security, in the hands of the state? If the liberal is able to answer this question, he remains a liberal. If he finds no reason why the state should have a monopoly, he becomes an anarchist. A different kind of anarchist than the one we see in the classical anarchist tradition, but an anarchist nonetheless. This form of anarchism has had many names like Anarcho-Capitalism, Market Anarchism, Libertarian Anarchism, Individualist Anarchism. All these names do not necessarily mean the same thing, but what they have in common is the belief that even and especially the field of security should be provided by the market. The opposition to security monopolies varies from anarchist to anarchist. For some of them, it is a philosophical argument. They strive to reduce the power of the state and choose to think about security when there is a limited government. Others, like me, believe limited government to be a myth. And why that is, we will get in later sessions. The book Anarchy and the Law, in the first part, we will be discussing the theory of private property anarchism. The second part is about the debate between anarchists and minarchists. Minarchists are people who seem to have reasons why there should be a monopoly over security and law by the state. And the third section, we will read about certain precursors to this thought, some historical articles by Walter de Cler or and Gustave Molinari. In the fourth part, we will be discussing historical examples of societies that have had certain elements of private property anarchism that we will analyze. Where they went wrong and how we can learn from those historical examples. In the first chapter is Stringham summarizing his compilation. He describes different works that he has included in the book. I will be referring to it for every chapter that we go through it. Second chapter is written by Murray Rothbard. Rothbard's brilliance is in merging Austrian economics with certain liberals, Austrian economics of certain liberals in the Austrian tradition, with the anarchism of individualist anarchists in the 19th century. In this chapter, Rothbard discusses the abolition of government in the service of protection, which includes courts and police, etc. So let us delve into this chapter. There is no doubt that private security is possible. It exists today. The question really is if private security has the capability to replace the state in providing us security altogether. This is that there would be no taxes and we would be protected by agencies that will rely on voluntary payments to protect its clients. I contend that this not only is this possible, but that the state and the state-supported security is undesirable, tyrannical, and downright inefficient. The first argument that Rothbard makes, being an Austrian economist, is that of the calculation. He points out that police protection is not an absolute commodity, just like how food and shelter are not absolute commodities. There are various different kinds of foods, and so too there are various different kinds of protections that people need. There is on-foot patrolling, cars patrolling, round-the-clock personal bodyguards. There can be different number of policemen assigned to patrol a certain block. Police also need various equipments and weapons like fingerprinting equipment, guns, bulletproof vests, patrol cars, etc. There can also be different specialized forms of labor in the field of protection. We have uniformed guards, detectives, and even spies. All these different aspects of protection need allocation of resources. However, government has no rational way to make these allocations because it is cut off from being affected by consumer. The consumer of the protection services that is us. We are the consumers of the protection service, but we don't get to pay for these services directly to its providers. Therefore, we as consumers are not able to economically influence the decisions about the allocation of resources. Suppose my neighborhood needs regular police patrolling due to high street crimes. However, I'm not directly paying the police officers to patrol here, at least not officially. What I can do, however, is that I can start a petition, try to influence political process, and try my best to get a policeman appointed to my street. This takes time and effort and requires going through the inefficient bureaucracy to get any change. This is just like how there are various different kinds of food possible. The farmer can grow rice, wheat, corn, and many different options. The price mechanism plays an important role here. If there is a shortage of wheat, the price of wheat will tend to be higher, and then there will be more farmers tending to grow wheat for more profit to counter the shortage of wheat. And just like how government interference, like Essential Commodities Act, police price caps, and outright monopolization of the production of food will cause malinvestment, so too will government monopoly over protection causes malinvestment. The pattern of protection services will not tend to be according to consumer demands, that is our demands, but the demands of the political class who is paying them and interfering in the allocation of resources. This will not be what you could really call people's police, because it is not the people's demand that have influenced their actions, but those of the political power. I don't think anyone can deny seeing this effect. We see our politicians getting 24/7 protection services, but even after such hue and cry, there is hardly any improvement of protection in Delhi. And this is not by accident. We are paying for police through direct and indirect taxation, but we have no choice over the services of our protection. We can't directly hire police to provide protection according to our most urgent needs. Our needs are decided by the political class. Now, there are certain localities that don't want anything to do with police, and then there are certain people that need special protection, like jewelers when they are transporting jewelry. Which of these services should cost how much? We cannot say that because their demands are not allowed to influence the price directly. So is the jeweler paying more or less for that protection services in the form of taxation? We can't say. When the allocation of resources is in different spheres of protection is not that decided by consumer preferences, they are decided by political preferences. Another place where we observe this political effect is that laws the state really enforces. No matter how much the state claims that it enforces all the laws, it cannot enforce all of them. The state is not God, and these laws are not natural laws. The enforcement of these laws require resources, and on what basis does the state decide what kind of law to really concentrate on? Here too we find that enforcement of law is not in accordance to the demands on the market, but in accordance to politics. There is a role of insurance in the market of security. You may insure your property and pay premiums on it. In such a situation, the insurance companies get an economic incentive to provide protection services. This service will be different from the state. The state police's main goal is to apprehend the criminal, and the recovery of property is really secondary. But the insurance company would have the primary motive to recover property. Catching the criminal is secondary. Because the consumer, after all, cares more about recovery than catching some criminal. Of course, this is not always true, but the monetary benefits of recovery mostly outweighs the psychic benefit of seeing the criminal caught. Also notice that an insurance company would likely to replace the stolen object immediately and then begin its investigation, whereas the state police just doesn't care and pays little price for letting theft happen. Police police has no monetary incentive to catch criminal. All incentives are internal, like promotion and reputation, which is again the reason why police behaves according to their political masters rather than what the consumers want. Insurance companies who are under contract to provide damage costs to the consumers would have incentive to recover as much of stolen property as possible. So in the kind of mechanism that we are talking about, we would allow competition to ensure efficiency, low price, and high quality of protection services. Imagine the resources that we waste on wars that are not according to consumer demands, but according to politically connected military-industrial complex. We ultimately end up paying for all of those, but we get nothing of what we demand, and that is because of lack of choices. That we are forced to fund them through taxes, and therefore we lose our economic power to influence their actions. Imagine all of those resources, if utilized according to the most urgent demands of the consumers, there would be a lot more reliable and trusted security services rather than a big brother that watches over us to control us. When we make a case for private security, so the first question someone asks is, what about the poor? The first thing we must realize is that security is important, but so is food, clothing, and shelter. Should the government nationalize food industry? Think of the farmers who actually have to produce food. What about their freedom? If you restrict their entrepreneurial freedom, you will find that they will quit being farmers and try their luck elsewhere. And we see this happening, that farmers are moving to urban areas because it is becoming increasingly hostile to do farming. The question of poor should not justify state's monopoly over security any more than it justifies state monopoly over food. We must, however, try to make security as cheap as possible so that the poor can afford it. And if you pay attention, you will find that the private security is not actually abolished from the market simply because state exists. We know that private security agencies do exist, and the only very rich are able to afford them. What might be the reason for the high cost of private security? We find that the state has severely restricted the capital investment in private security. You cannot simply start a private security firm even if you have the capital. You need to get gun licenses, security licenses, and state approval, all sorts of things. So you cannot legally protect victims of. You also cannot protect victims of state violence legally. People who are thrown off their lands, people who are arrested for victimless crimes, their arrests cannot be interfered with. There are also certain standards that you need to follow. So you can't even start a primitive security agency that may cater to the poor. All that capital gets invested elsewhere, and private security services never reach the poor. But even then, we can answer that the very poor can be provided security through private charity, mutual aid, or by security agencies trying to maintain goodwill among its customers, like several doctors who provide their services for free to the poor. But remember that the main argument is that if we had free market security, capital would flow more freely into this sector, and we would have lower cost security services that the poor can afford. The last, we must remember that state police is not free for the poor. It might very well be that poor end up paying less to a private firm than they pay to the state in the form of direct and indirect taxes. Next objection one faces to the concept of private protection agencies is a potential war. Wouldn't the security agencies keep fighting? Suppose your TV gets stolen and the protection agency finds that I have stolen it. Then it comes to retrieve it, and I say, well, I have my own security agency who's going to protect me. Now, what we have here is two security agencies in conflict with each other. Your agency is convinced that I have stolen your TV, but my agency is convinced that I have not stolen it or wants to protect me regardless because I pay it very well. So, would there be a war? I don't think so. First is that war is costly. The states go to war with each other because of their ability to tax us. The states earn their revenue for war not by being producers but by being parasites. There is also virtually no limit to how much a state can tax. So if it depends on military warfare, if it spends on military warfare, no one in the state loses any private money. In fact, the weapon manufacturers stand to gain business from state spending on military. But a private agency will have to manage its own expenses. It cannot tax to compensate. So it will be judicious in its use of weapons, and therefore there will be a tendency to avoid war rather than to seek it. Perpetual war will cause them to increase spending on weapons and increase salary of their security personnel, which will cause them to increase their prices for consumers. In a market of competition, they will start to lose customers to other cheaper agencies. Secondly, war also tends to damage other people's property. People who are not involved in the conflict. State gets away with this because we don't hold it accountable. We have all accepted that collateral damage in state wars are normal. If India is at war with Pakistan, and then we accept it's normal that Pakistani citizens or Indian citizens are attacked in this war and vice versa. We never hold states accountable because there is no private responsibility in that institution. The governments may change and its relationships may change, but we continue this madness of unaccountability. But the collateral victims of a private war and their agencies would retaliate, escalating the potential cost of war, which they would have to pay for themselves. And if they try to settle it in the court of arbitration, the settlement cost will be high because there are more victims now and more damage to property to compensate. No private security agency can survive on the market if it gets into clashes regularly. If it is not funded by taxation, it needs some mechanism by which these clashes may be avoidable as much as possible. And this is where the concept of arbitration comes in, that is private courts. But before we move on to private courts, I want to say another thing about the imagined war between private firms. No matter how many times I make this argument, people have a hard time being convinced that war would be even less likely with private security agencies. People imagine the worst with private security, but somehow imagine the best with state, even when the facts are against the state. Our world is full of conflict. It's all around us. There is no denying that. But in being afraid of the possible war between free security agencies, not under a state, with no legal authority to tax us, we are ignoring the damage done by the state to its own citizens. The number of citizens killed or affected by bad economic decisions cannot be measured, but the number of people who have directly been murdered by their own governments, the governments that they called as their own government, is 262 million people in the 20th century. In the 19th century, this number was 190 million. This term is called democide, and it does not include war. In the 19th century, war deaths were actually more than the democides, I think. The 19th century figures are not clear. It was quite some time ago. In the 20th century, however, deaths were surpassed by democides. So war deaths were surpassed by democides. What we are therefore doing is that we internalize the conflict around us. We are hiding behind an institution that exploits us, and we let it do it because we are afraid of the uncertainties of the real world. So far, we have discussed security services, but we also discussed that protecting someone may involve coming into conflict. How does this conflict gets resolved? Before we discuss that, anyone has any questions?
No, I don't have any questions.
Okay, so yeah, so far we have discussed security services, but now we need to discuss how conflicts are resolved. If there is no mechanism possible for this conflict to resolve without the state, then we might as well forget about free market and security, because if there is a monopoly over arbitration and law, then all conflicts will be resolved by that monopolistic institution, and the security agencies that it rules in favor of will become just like the state police. They may even be worse, seeing as how they are not bound by the sentiments of democracy. What I'm trying to say is that arbitration and security go hand in hand. We can't have a free market in one of these services and not have it in another. One usual argument that is made against private security agencies is the examples like Blackwater. I'm not sure if you've heard of this company. This so-called private security agency provides most of its services to the United States government. So it's not a security agency in the free market. Most of its revenue comes from doing the government's bidding. And it is worse, it has the freedom of a private agency that the government does not enjoy due to restrictions imposed on the government institutions by various movements. This is just like what we do with PSUs, public sector undertakings, are government-owned private companies. They have the freedom of private companies but still enjoy the government funding and contracts. When I say private, I specifically mean that which is not funded by taxation. Something that thrives on the government funding is not private in my eyes. It is the extension of the government. We have railways department that runs the railways, and the government sets budget for the department. The government could very well have called the railway department as private and put it under contract instead of budget. The situation would only be marginally different. The so-called private railways would be funded by taxation just like today. I wanted to clarify that before we move forward. So let's talk about arbitrators, and then we will talk about the role of the state courts as arbitrators. A lot of writings and videos on the subject talk about polycentric or private law as it is fully developed, as if it springs into existence. But we are going to take a different approach today. We will think about what justice is in a primitive society, and then the problems with primitive style justice, which is closer to the jungle law. Then we will introduce the concepts of division of labor into it, complicating the market system to get an idea of how justice system could have evolved if state violence had not been legalized in the eyes of the public. Then we will discuss why society did not evolve this way and why a state wishes to maintain this monopoly over the law. Just 1 minute. Okay. Okay, now imagine a primitive society with no state or any other macroeconomic institution. In such a society, suppose something of yours gets stolen. How will you get justice? In this society, you must get justice for yourself. You will have to find who stole your property. You'll have to track that person down, and then you'll have to recover through the use of force what is rightfully yours. You might want to take something of his to either punish him or for compensation of your inconvenience. You also wouldn't want to overdo the punishment. If you killed him, for instance, out of revenge, you may be targeted by his friends. you will recover as much of your property as you can so as to keep this conflict, so as to not keep this conflict ongoing. But it is important to remember that you do have the right to recover your property yourself. You shouldn't need permission of anyone else. Recovery of the property by you would be what we could call justice in that society. Now there are some problems in the system. If it was not, if there weren't any problem, we wouldn't have evolved past it, of course. The first problem is that you'll have to find the thief yourself, which is not always an easy task. A thief is specialized in stealing, but you are not specialized in tracking them. Second is that you will have to depend on your own strength to recover your property. If the thief is stronger than you, then you won't be able to do justice. The third is that while your property is missing, you obviously can't use it. So there is no replacement. If your cycle gets stolen, you would have a hard time even tracking down the thief because you can't travel easily. So how can division of labor solve this problem? First is that suppose a person or a group decides to study the art of tracking down thieves. This person could then be approached by you for help in tracking down the thief. These people are what we call detectives. Now, why would a person do this? Because he gets paid for this job, like every other profession, because he solves one of the problems of primitive justice. So once you find your property missing, you approach a detective and pay him to find the thief. He finds him, and the rest of the story is as before, but so are the rest of the problems. A detective may not agree to recover the stolen property for you because he's not specialized in that regard. He's not a trained personnel or a fighter. So suppose another person sees this problem and then trains himself in the art of recovery. This would require some tactical and physical training that neither you nor the detective has. These people may band together to form a recovery agency. So now you can hire the recovery agency and say, this person has stolen my property, won't you recover it for a fee? And this fee can be compensated by the recovery agent when he recovers the stolen property plus the restitution. In fact, the unsuccessful recovery of restitution, you can probably cover your costs of the detective and the recovery agent. Now, the recovery agent would not like to recover something that was not stolen. So if you are lying to him, he would like some proof before putting himself at risk. And if there is proof, then recovery may also be violence-free, as the thief would have no excuse when the recovery agent turns up at his door. So the recovery agent will have to trust the proof that has been collected by a detective. This means that they will be seeing each other on almost a daily basis. This is where the aspect of reputation starts to come in, the reputation of the detective. So this system still has some problems. First is that you might not have enough money to hire a detective and a security agent, a recovery agent immediately. If a lot of your money gets stolen, the detective might not agree to work on a case that may lead to a dead end. Restitution is only possible during recovery. If there is no recovery, the detective earns nothing. So he may refuse to work for you without being paid upfront. The recovery agent may also refuse if he has doubts that the recovery may not be certain. Second problem that now arises is that what if the thief also has a well-trained person or an organization defending him and his innocence, like a defense agency? Then there could be a bigger conflict. The first problem is solved by someone running an insurance company. You may agree to pay monthly premiums to the insurance company, and when you get robbed, the insurance company may step in and provide you restitution beforehand. This way, you're not interacting with any detectives or recovery agents. You're simply paying premiums to the insurance company, and they are replacing your stolen object as specified in the contract. This is like theft insurance. Now, do we need detectives and recovery agents? Well, yes, because insurance company doesn't like losses. if there are too many thefts, the insurance company is likely to lose a lot of money. So in this case, the insurance company, not you, will hire a detective to find the thief, and they will also hire a recovery agency to recover the stolen goods. Even if you were robbed of everything you had, the insurance company would now be paying for the recovery, because if you had been paying the premiums according to the contract. Notice that there is no arbitration occurring anywhere yet, but arbitration is possible in every step of the evolution of the system that we have discussed. Even in the primitive justice, if you find the thief, you may be able to get your stolen object by simply arbitrating with each other. It might not lead to a big fight or trial by combat. But let us instead think of why arbitration is needed in the most advanced system that we have constructed yet. So suppose the recovery agents of your insurance company contact the thief and ask for your property back. Suppose the thief refuses or pleads innocence. Sorry. Well, if the insurance company is very sure of the theft, it can still recover the stolen object by force, but that is not likely to happen. Even the state does not let that happen. Why? Because to a new onlooker, recovery is the same as theft. Imagine if I see you taking some bike that someone else has just parked. My first thought would be that you are a thief who is stealing the bike of the good man who just parked it here. But what I would be doing is assuming that possession means property. That since the object is in the possession of the person who just parked it, it is his property. And most of the time that is true. But what if you were simply taking back the bike that was bike-jacked from you the day before? I do not know that. So there is always a threat of public backlash against recovery, because the public doesn't know if the object is being recovered or it is being stolen. How the insurance company may solve this issue is by having a public trial. They may say that if the accused wishes to defend himself, he may come to our court, which is in fact no different than an office, because it doesn't have the reverence of a state court. And he may defend himself by going there. Now here too, the reputation of the court may matter a lot. So there might be a separate agency that specializes in creating neutral environments for court hearings. Now suppose that the thief is not cooperative. The recovery can be done by the use of force now, and there is less of a chance of someone else interfering. But here comes the big problem. Suppose someone does interfere, or the thief himself hires a security agency to protect him. Now some people start to get the thought that there may be war between the private agencies. But we have discussed this already. War is not profitable unless it is funded by taxes. It depletes the resources of the private army and tends to make it bankrupt. If there is no concept of arbitrators, then they may still not go to war. The stolen object may just not be worth it for going at war over it. The insurance company is already earning from its premium. Why would it threaten its financial stability by going to war over every stolen bicycle, television, home robbery, and things like that? But then no insurance/protection agency would like to be on this side of injustice. So there's a huge tendency for them to pre-assign arbitrator amongst themselves. They are, after all, going to be dealing regularly, and it is better to have a pre-approved arbitrator to solve these disputes. Both these protection agencies will agree to abide by the arbitrator's decision beforehand. A lot of people ask, why would the protection agencies settle on one arbitrator? Wouldn't each of them would like to choose a biased arbitrator that is biased towards them? This argument is given by those who accept that there must be a free market in security and reject free market in arbitration. They make a case that there should be a final arbitrator in case of private agencies, in case the private agencies do not agree to settle on a single arbitrator. But we've already discussed that you can't have a free market in security and you not have a free market in arbitration. And now we have seen that there is in fact an incentive for the protection agencies to choose a just and unbiased arbitrator, Because if the client of agency A is a thief today, a client of agency B can be a thief tomorrow. And the role of the arbitrator comes in when the security agencies want to settle the dispute. The idea of fake courts is therefore laughable because it misunderstands the role of arbitration itself. Now, the arbitration agency, which specializes in the problem of solving and are known for their keen sense of justice, will be looking at the evidence just like a state court would. Then it will publicly announce the results. Suppose that it finds the accused was actually the thief, then the security company gets out of the way and recovery is possible. If the accused still tries to fight back, there is no one to protect him versus an entire might of a protection agency. If he is found not guilty, he is paid restitution by our agency for all the trouble caused, and there is now an incentive for the insurance agency to improve its detective work. Now, a society where this type of distributed justice system has been functioning, you will find that there is a network of market relations where there are multiple insurance and protection agencies, and there are multiple arbitrators who act as disinterested third party in various protection for these various protection agencies, which is why it has also been called a polycentric legal order as compared to the monocentric order of the state justice system with the Supreme Court at the center. Any questions till now? I'm really getting a sore throat.
Here I think Rothbard doesn't talk about the premium of insurance companies. Certain crimes, I think, certain valuables and certain things will have a will attract a higher rate of insurance premium and stuff like that. So maybe that's a
Yes,
point you can elaborate.
yes, yeah. So that is also true. Just like how, in fact, the argument that he says that the state does not know which laws to implement the most is now, of course, some things are really obvious that a murderer should be caught before a thief is caught, but it is not always true in the state's functioning. But it could very well be in a society where there are a lot of murders. The life insurance cost could be very high, and then the insurance companies would have the uh, would have the would have the incentive to look into these crimes, and then they would be they would have incentive to invest in specific type of detectives who are good at forensics and postmortem. So yeah, that is also true. Anything else? Okay, then. This was just one example of how disputes can be resolved in criminal cases. Hayek called markets as a process of learning. Who knows that in the process of learning we find better ways to resolve our conflicts. In some historical cases, in fact, private arbitration has existed without a private police enforcing it. Take, for instance, the mercantile courts that existed from Middle Ages up until recently. Their decisions were not enforced by any police. How they functioned was that if there was a dispute among two merchants and they took this to a mercantile court, if one of them did not abide by the ruling, the court would make that name public. If a reputable court says this merchant Smith made a contract with John and did not follow through, so if you're doing deals with Mr. Smith, uh, please keep this in mind. This would be really bad for your business. So the enforcement was done by fear of losing reputation on the market and through ostracism. We will study more historical cases of the past in part 4 of this course that the past polycentric orders were peaceful societies, uh, there was where arbitration was rarely enforced through the use of force. Arbitration is a conflict resolution. One example that Rothbard gives is medieval Ireland, which has one of the most, which was uh, for its own time, it was quite advanced society. They had similar system of voluntary law where they enforced criminal laws by ostracism. Criminals were not punished in the sense that they were punished today, but they were declared to owe restitution money to their victims. They therefore became debtors and had to work to provide that money. If they refused, they would be declared as outlaws and they would be ostracized from the entire system with no one protecting them. You can read about it in page 26 of the PDF that I had shared. Uh, and and by the way, Ireland survived for 1,000 years before its anarchy was crushed by England. And for 1,000 years, it fought no major wars or involved any or invaded any country. There were conflicts, of course, but they were mere brawls compared to what was happening in Europe at that time. Efficient arbitration on a free market tends to minimize conflict to such an extent that the use of force may become very rare. In one historical example, even that of the Iceland, the criminal justice system lacked the use of force, such as the capability of peaceful human interaction. The system that we described has one element of reality that the state lacks. No one has the inherent right to rule, and neither uh, God nor democracy can give anyone the right to rule. If you put a constraint that whatever system you design, there should be equality of authority, you would get approximately the system that I described. But state is a forceful monopoly over arbitration of disputes in a geographical area. The state, by the use of force or the use of stolen economic power, the state is able to override any dispute resolution that could happen outside its own system. The state is therefore the final decision maker for a given geographical area. Why does the state do this? What incentive does the state have to take over this monopoly? Remember that the main purpose of the state is predation. It is a systematization of political means of earning wealth as opposed in a geographical area, as opposed to earning wealth through production and exchange. And when the state expropriates property, and I don't, by the way, I don't see a difference between expropriation and eminent domain. So when the state expropriates private property by land acquisition or by direct and indirect taxes, it is able to defend those actions by law. At some point, the predators or the mafia or the thugs realized that their predation is better protected if it was legalized. If they simply had control over the general perception of what is legal, they would be able to legalize their predatory process. It is like we were forced to accept only one protection agency which claims to have the power over final arbitration, even in cases where the agency itself is in conflict. In the cases of state versus you, the state is the arbitrator. If a state agent wrongfully detains you, any court case that you can do will happen in the state courts using the state law, which mostly protects the state agents from repercussions of their actions. A policeman murders someone while doing their job, that situation is treated differently than accidental manslaughter by a private citizen. And if you were wrongfully convicted, there is no compensation that could be given because the state owns nothing. It loses no private money if it compensates you. There is no incentive to be more careful while convicting people. All compensations for the wrongful actions of the state are decided in the state courts and are paid using tax money. Obviously, I'm happy for those who are compensated, but there is no private responsibility, no private losses, just socialized losses. What I wanted to show is that for the state to provide this supposedly free services, you do pay taxes. You must ask yourself what is the motive? Why do some people agree to provide these services. Let us start comparing the system that we have described with the state justice system, and how some of the disincentives that exist in the state system do not exist in a free market. As with police, we will first start by criticizing state courts on the basis of calculation problem. Firstly, how are judges selected? I know that we all like to think that judges are above the system and that they provide the various checks and balances on the corrupt politicians. But aren't the judges themselves appointed by the corrupt politicians? Does this process also not bring in politics to judicial appointments? It is the general understanding that the judicial system is apolitical and objective, that keeps a tab on functioning of the law. However, isn't the law subject to modification by the same corrupt politicians, which these judges have to uphold according to the law? We will get into this topic much deeper when we get to the chapter called Myth of the Rule of Law. But for now, we only need to understand that judicial appointments are political rather than objective or through markets. Judges aren't necessarily chosen according to their wisdom and efficiency. There are many wise and efficient prospective judges, many of whom are lawyers for decades. How then, if not politics, is their appointments done? The fact that judicial appointments are political is something that people know but are afraid to say. Secondly, the state courts are a monopoly. Should a state court in a locality go corrupt, oppressive, or inefficient, the citizens have no recourse. In a free market, in courts, there will be many courts which will act as arbitrators, and they will have to cater to the customers' demands, just like any other market institution. Since they are chosen by various parties in disputes, the selection of judges will be in accordance to the parties in dispute. As in every other sphere of economic activity, this process will tend to ensure efficiency in arbitration. While the state judges are politically selected, a political private judge will have a hard time finding clients. The crucial difference is that the state courts are funded by taxation, so the consumers will have little effect on their judgments, while the private courts will be paid by consumers who are using them. The state courts are also inefficient for many reasons. First is that the laws that they represent are not discovered on the market. As we discussed before, the law in a free market would be the function of the arbitrator, whose purpose is to resolve the conflict. In such a process, he would discover that there are some laws that could be written down and looked up for his reference when resolving disputes. Big libraries in past arbitrations may exist where the arbitrators could study and understand how past arbitrations could have resolved this particular issue that they are facing. But the state law is not discovered on the market the same way it is legislated. Assuming that the legislative body has the good interest of the public in their hearts, which is a big assumption, that is obviously not true. But assuming that, how does the legislators know what laws best resolve the conflict between people? As a result, many of their laws create conflict rather than resolve it. There are so many cases in courts, many of whom are there for victimless crimes. These laws do not resolve conflicts, they create them. These laws do not do grave injustices. In fact, if the laws were so objective and straightforward, we wouldn't need judges to interpret them and apply them to certain situations. To do best possible justice while remaining within the bounds of the law, and this too assuming that the judges aren't corrupt and have the best interest in resolving conflicts. But that is obviously not true. Remember that the primary duty of the judge is to uphold the law. Resolving conflicts is secondary. While the arbitrator in the free market, his primary motive is to resolve conflicts. Due to these inefficiencies of the state justice system, they have become more and more clogged up, and they are trying various means to overcome that. Fast track courts are one example, but we know that that didn't work out as much as we thought. In a free market, such fast tracking would tend to happen automatically, and it wouldn't happen politically, but according to the needs of the consumers. The insurance or protection companies would find that a lot of cases of a particular type are coming in, They may themselves hire experts in the field to minimize their losses and invest in protection and arbitration of these criminal activities. Just as market tends to utilize capital goods to their most valued ends, as demanded by the consumers, a free market in protection would tend to concentrate on punishing crimes that are most needed of being punished. Compare that to today, where we get fast-track courts by way of protests, which is again a political method. Another argument is that is usually given is that in anarchy there is no final arbitrator, so you need one final arbitrator of all disputes in case the dispute is unresolvable by voluntary arbitration. This is a straw man. The final arbitrator exists in anarchy. It just necessarily isn't the same person for every arbitration. Arbitration services cost money, so it isn't true that I'm going to keep on appealing to different arbitrators on the market. In fact, most arbitrators would accept the fee and simply ask for the case filed from the previous arbitrator and make decisions quickly. Unlike the state courts, the arbitrator would have an incentive to dismiss off cases already resolved by the various other arbitrators. Unless some new evidence is found, the decision is going to be enforced no matter how many times it is appealed to different protection agencies. Compare this to how however, a hierarchical appeals process goes through, where cases go from lower courts to the Supreme Court. Under the state, many judgments of at the local level become defunct because of the constant appeals to the higher courts. For a criminal, for a criminal, this is good. He has nothing to lose by taking cases to the higher level. It is even funded by taxpayers. The fact that the polycentric legal order lacks hierarchy and a top arbitrator, which is different from final arbitrator, works out in anarchy's favor. So it is not surprising that intentionally there is a booming market in private arbitrators, and there's a huge lobby that wants to pass laws that do not interfere in private arbitration. If private arbitrators pass a judgment on the willing participants, then the state should respect that decision. Otherwise, the arbitration would be meaningless because the state could override it. So while still having elements of monocentricity, the markets are trying to break free of the state. Any questions till now? Okay, let us now talk about protection agencies that may protect rich outlaws. Wouldn't the system that runs on money be susceptible to be used by the very rich into buying more gunmen and courts? Wouldn't these rich men then try to use the courts to pass biased judgments against the population? If so, then this would again be systematization of predatory process where the rich outlaws court would acquit rich outlaws gunmen who is collecting taxes and maybe calling it rent. So let us try to analyze how a free market could deal with a corrupt court and protection agency. We have to realize that this fear of corrupt courts is something that we have got from the state courts and not from the courts in the free market. If a state court goes corrupt, you don't have much choice in the matter. A corrupt state courts are able to remain in operation because of a few reasons. First is because the courts are able to maintain a public image of superiority rather than effectiveness by advertising themselves as public courts. Private courts, on the other hand, lack this public image of people's court, so their decision cannot be passed off as for the greater good. Suppose that I am a rich outlaw and I grab a land from some villager. Then I set up a court and acquit myself of this act. In a private law system, this decision of my court will have no value. Arbitration was not done, and this court would not be recognized to have any real value on the market. Unlike the state police, which has to follow through the decision of the state courts in a free market anarchy, the private protection agencies do not have to follow a decision of an arbitrator that is not chosen or accepted by them. The protection agency that the villagers may form or contract will simply not accept the corrupt court's decision. The same is not true for the state court, which hides behind the land acquisition law and upholds the act of land grabbing, if only it was done by way of government. The reason this is so is because the state has a special place in the minds of the people, which is what we are trying to combat. Bad and corrupt people will always exist, but should we give them the state to legitimize their act of theft? People usually say that we have designed a system with checks and balances that keep state justice system from going corrupt. But I think that that is just wishful thinking. Any checks and balances that you create will be internal to the state organization. Everyone from the police to legislators to judges and even the public defender earns their income from taxes. They all have the same source of income. No matter the checks and balances that are internal, as long as their sources of income is the same, those checks and balances will not work for situations that may threaten their own earnings. And if you see, most of the internal checks and balances are simply to take care of situations where one member of the state tries to cheat the other member of the state. These checks and balances are just like internal checks and balances of a corporation like IBM. Would you accept one department of IBM arbitrating a dispute between you and another department of IBM? Obviously not, but the state has a very good ideological stronghold that allows it to get away with it. On the other hand, market provides what we can call external checks and balances. The private protection agencies have to compete with each other to get market share from the customers voluntarily paying for their services. There is actually real economic incentive for an agency to expose other agencies when they try to go corrupt and hoodwink the people. But you can write checks and balances on paper all you want, but it is real economic incentives that will actually make people keep a check on each other. Certainly, you always got some sort of advantage if you are rich. It's good to be rich. You're always in a better position to bribe people if you're a rich man than if you're not. That's true, but under the current system, the power of the rich is magnified. Suppose that I am an evil rich person and I want to get the government to do something or the other that costs $1 million. Do I have to bribe some bureaucrat $1 million to get it done? No, because I am not asking him to do it with his own money. Obviously, if I were asking him to do it with his own money, I couldn't get him to spend $1 million by bribing him any less than $1 million. It would have to be at least $1 million and 1 cent. But people who control tax money, they don't themselves personally own and therefore can't do whatever they want to do with it. The bureaucrat can't just pocket the $1 million and go home, although he can get surprisingly close to that. All I have to do is to bribe him a few thousand times, and he can direct his few $1,000s, and he can direct his $1 million in tax money to my favorite project or whatever, and thus the power of my bribe money is multiplied. Whereas if you were a head of some private protection agency and I'm trying to get you to I'm sorry. Sorry, Bhavin, I'll talk to you a little later. So because I couldn't get him to spend $1 million by bribing him any less than $1 million. It would have to be at least $1 million and 1 cent. But people who control tax money, they don't own personally own and therefore can't do what they want with it. So I can pay him $1,000 to direct the $1 million anyway. Anyway I want. Whereas if you are a head of some private protection agency and I'm trying you to do something that costs $1 million, I'd have to bribe you more than $1 million. So the power of the rich is actually less under a libertarian system. Another objection that is usually given is that if the protection agencies decided to band together to form a state, they all will refuse to protect against theft if it was done by a select group of people for some select purposes. like taxation is. In such a situation, we would again have a systematized predatory process. Well, what can be done in such a situation? Well, nothing. There isn't some magic system that grants us permanent liberty. It is ultimately compliance of the subjects of predation that makes it possible in the long run. What we need to ask is whether such collusion is less possible in what the general population perceives to be private sector than public sector. After all, even public sector isn't completely a cartel. The police plus army make up the entire might of the state. Why do they continue to let some politicians with no guns boss them around? A military coup is not unheard of, but it doesn't happen all the time. Again, it comes down to to public perception of what is acceptable and what is not. A private defense agency does not have the authority to tax. Its taxation would be considered robbery. One of the crucial factors that permits government to do the monstrous thing they habitually do is the sense of legitimacy on the part of stupefied public. The average citizen may not like, many even strongly object to the policies and extractions of the government, but he has been imbibed with the idea, carefully indoctrinated by centuries of government propaganda, that government is his legitimate sovereign, and that he would be wicked or mad to refuse to obey its dictates. It is in this sense that sense of legitimacy that the state's intellectuals have fostered over ages, aided and abetted by the trappings of legitimacy, flags, rituals, ceremonies, awards, constitutions, etc. A bandit gang, even if all the police forces conspired together into one vast gang, could never command such a legitimacy. The public would consider them purely bandits. Their extortion and tributes would never be considered legitimates, uh, like taxes are. The public would quickly resist the illegitimate demands, and the bandits would be resisted and overthrown. Without resorting to violence, if the agencies try to form cartel and hence establish the state, they'll find it hard to compete with each other while being in the cartel. They will have to use the market to get as much revenue from the people voluntarily, which is why cartels which are not forceful tend to break up in a free market. Let us look before we get into the question of national defense. Does anyone want to discuss something? Or let me take a 2-minute break. My throat is really paining. Shikhar forwards a comment from someone. This means that we could very well be shot dead by a private justice agency to which a rich man has paid a lot of money. There is not much to distinguish private agencies uh, from a Bihar mafia. No person in his right mind would ever entrust his life and liberty entirely only to a private police or justice system.